born when you started. But I am closer to 40 than 30 now, as of last month. I am 36. I've been practicing since 2012, so 11 years now. In title since 2006, so I got to see the crap at the end of that decade. I got to see a lot of good stuff in the interim. I always talk about in this group, there isn't a deal that I haven't seen. I promise you that. Real estate's super unique, especially when you investors bring deals to my table. I like easy ones too, right? I will get you to the finish line most of the time, if I can, whether it's judicially or not, in court or not. But yeah, we have a lot of fun. Tim and I have been closing for a better part of a decade together, and a lot of people in this room have closed with me. So we appreciate that. Like Tim said, you're here to get more deals. I actually invest myself as well. I like to be a part of what I help you guys do, right? Time permits. You have a daughter, I like to be a part of her life too. But so not only do I close, I invest, and I'm here to help you guys get those deals closed, right? I mentioned that I hardly ever am not able to get something to finish line, but we're going to be ethical, we're going to be legal, and we're going to do everything by the book. But we can't get creative. There's one that I had the other day, and this isn't part of today's topic, but there's one that I had the other day where I had to deal with folks who acquired the property in 1941. Lenny probably remembers them. Yeah. He died in 75. Not Lenny, though. They had one son. Son died in 95. And surviving spouse, widow, passed in 1999. The probate was done in 2000. Okay, probate was done solid. 24 years ago, right? So what I'm telling you, this timeline, I always have to do the timeline. The laws changed in 93. What did I tell you? He died in 75. So he's subject to the prior laws, which say if nothing was done with his estate, he didn't leave a will, of course. So there was no probate. You can't probate without a will. That's another class for another day. So no will, no probate. But then Novi's probate in 2000 was solid. But you still can't forget about his interest, right? And the laws before 93 said if you die intestate without a will and there's no probate, half of your stuff goes to your kids. I say stuff, but half of the community interest, which is 50% of this property that I'm trying to close, went to his kids. What did I just tell you? His only kid died in 95. We're not going to get in the weeds, but those are the fun types of deals that were brought to me when people are always, most of the time, misunderstood with who can actually sell the property and why I had to pump the brakes there and say, look, you can't sell the property, sir, that inherited and received was a beneficiary of the probate from 2000. So I said, I'm not David. Every year I go down to the Texas Land Title Institute, probably somewhere around here, down in San Antonio. I am part of the Texas Land Title Association. I am part of the Political Action Committee on the board there. Very passionate about title. As you heard, it's been my life for almost 20 years now. David presents to not only lawyers, but title professionals, escrow officers, title company owners like myself, and that's where we get our case law update. I'd like to see that. I'm not going to reinvent the wheel or make another PowerPoint like Tim enjoys to do. I don't. So I just use David's, all right? And what we talk about down in San Antonio annually, he's been doing it most of the years that I've been since 14, I bring to you guys, right? Not only am I bettering myself and my practice, but going to share what we learned. Keep in mind, this is case law. This isn't statutory, right? Congress is going to meet here, next week, right? Session's about to start. That's when the legislator might start changing. What's that?
Maybe.
We've got a speaker of the 15th ballot, right? So this is case law update. Okay, keep that in mind. We're going to have a discussion. Let me back up. I'm going to act like my law professors from way back when. Don't try to get to a conclusion right away. Okay? Think about the Socratic method. Have a discussion, whether it's with me if you ask me a question or whether I invite it. Don't try to get to the conclusion right away. We're discussing the fact patterns, and we're analyzing the facts and applying them to Texas law. Right? In mind, it's only Texas law, no license here. We're only talking about Texas case law updates for property issues. Some of these are Court of Appeal cases. Some of them get to the Supreme Court. I'm sure if any of us were going over our district level, maybe a couple, but there's mostly controversies and things to talk about when cases are appealed and go to the appellate level or the Supreme Court level. Okay. Questions before we get started?
I have a comment.
Yes, sir. Comments.
Just want to clarify something. I just heard you say 40? 40? Your face?
I'm closer to 40 than 30 now. Just turned 36.
So your Facebook post said that you just had your 50th or 52nd birthday. Are you pulling our leg or what?
Yes.
It said enjoying his 50th or 52nd birthday. I'm going, Martin, 50?
You know another Martin Garcia? You're not telling
It
me?
had a picture. It had a picture.
Is there a fake profile? All right, you got me. Is there a fake profile of me going on there?
Maybe.
Must be mileage, not model year.
Yeah. Show it to me later. Now you got me.
That's a good one.
I thought maybe you're just, you're 50, but you're saying you're.
You mean I didn't send you that picture? You're just double it.
Nah, I put it in FTX for you.
I think some people would appreciate when you say statutory, explain why you say that.
So the laws of the state of Texas are codified, right, in the codes. So the codes that I use in practice narrowly are the Texas Property Code, the Texas Estates Code, and the Family Code. Those three are the regular statutory laws that I put into my practice and use. So that's what I mean by statutory. The codes, the laws that are codified after a session, they meet, right, and finally approved by both chambers, the governor, and then put into law. Okay. After session, we can have a smaller version of this to see what is going to be codified or recodified, right? If the statutory laws are going to change. The Estates Code hasn't been around since 14. It used to be the probate code, right? Things like that might change after a session. So, hopefully that helps out a little bit. Anything else? Okay. Out of the table of contents, Tim, he and I agreed to go over promissory notes, deeds and conveyances, easements, leases and evictions, POAs, restrictive covenants, adverse possession, and zoning and land use. So those are the topics that we're going to hit. And of course, these cases have specific fact patterns that have to do with these underlying topics. Okay. First one's promissory notes. I'm on page 1 after the table of contents. Angel versus Tosh. This got to the Supreme Court. Bank held a $4.6 million judgment against Tosh. All right, the bank tried to settle that for $2 million, but soon thereafter, after saying Tosh, act quickly, you got to pay this, less than half. The bank actually ended up assigning the judgment to another creditor. Thinking already? You made an offer, right? I'll settle this for $2 million, but then the bank went and assigned it to somebody else. So that's what begins the issue here, okay? The bank and a trust that was involved rejected Tosh's assertion that a binding contract to settle debt had been formed by his acceptance before the assignment agreement's effective date, okay? There was a dissenting opinion in this case that said the effective date was immaterial because precedent set the standard for an implied revocation as requiring only some act inconsistent with the offer. Okay? The court held that the doctrine is not constrained to land transactions, and the touchstone is inconsistent action manifesting a lot of legalese here, right? The offeror's unwillingness to enter the proposed bargain. Okay? Basically, it was a revocation of the offer to assign. Okay? We're not going to get into the weeds of the facts there, but that's what I want you to pull out of that one, because how many of us here use assignments? Make offers daily, right? think about that principle right there. Whether you have a verbal offer on the table with one of your potential clients or purchasers or sellers, and whether or not you use assignment. I have assignments on my desk every day, and I see all sorts of different assignments. Some of them are garbage, some of them are good, right? But keep in mind, what's the basis of your bargain? What's the basis of your agreement? Because you could not have a deal based on what your actions are after the fact, right? Here's a settlement offer. I'm going to assign it to somebody else. Are you even part of that deal anymore? Do you even have standing here in this issue? No. It's basically a revocation by your action. Make sense? Yeah. It's revoked. Basically, yeah. Hey, I'll settle your debt. Pay me 2 out of the 4.6. And then it's like, hey, 10. I got this judgment against her. You want it? Right. I assigned it to Tim. So it's basically a revocation.
Even though she wasn't aware of it, the offer was revoked. How can that be when it's verbal and everything has to be in writing? Would they enforce it?
It was based on the effective date, but it wasn't right away. An offer can be revoked without express words of revocation so long as the offeree had knowledge that the offer had acted inconsistently with the offer. So acting inconsistent. And the effective date was a trigger point.
So the fact that the debtor didn't pay that the same day or the next day, whatever, was they're out for revoking it, even though they didn't disclose that in writing. They didn't say
they said act
pay
quickly,
it by
right?
tomorrow,
Right. They said act quickly.
and that's it.
Yeah.
Time is of the essence, basically.
Yeah. Act quickly. The bank would likely be looking at other collection alternatives.
Okay, I didn't hear that.
Well, I'm not going to read it all. It's boring. And
Yeah.
I'd like to have more of a discussion. But I encourage you guys. Go share this PDF. Yeah, go through it. There's a lot of stuff that we're not going to touch on today. But yeah, I'm going to peruse and jump through the patterns.
Yeah, this will be uploaded on the calendar page at the bottom, just like the video.
Page 3, please, Tim. And then up to 4 soon thereafter. So that was a promissory note issue. Okay, that's what the judgment was triggered on. That's why it's in that section. If you want to stick with notes, if anybody has any questions, Brian might have something to add. Dan might. Any issues that you've run into at any of your notes? Who's creating notes? Who's buying notes? Who's originating notes on the finance type of thing? Nada? Yeah. Go ahead.
Well, I don't really have a question, but I've done notes in the past. And,
Yeah. Any questions, or you're just saying that that's part of your
yeah, no question.
trade right now?
No question.
Was that a sale of a note that happened in this first case? Did they sell the note, or it was a judgment
It was
on
a
the default?
It was a judgment.
On
Yeah.
the default, and then
That's
they
right.
assigned it to a collection agent.
Yeah, I mean, we've talked about it, Tim and I, and whoever's been part of this lawsuit with me. You can get a judgment all day, but collect you on that 4-6. So that's why that's why it ends up being part of the case law update when professors say that's why it's in your book, right? Yeah. The fun fact pattern. So deeds and conveyances. Aaron B. Fisher. This is the appellate district over in Eastland. The question is whether from Lilly to W.T. and Chester conveyances were gifts or sales for consideration. If they were gifts, then mineral interest would be separate property. If they were sales for consideration, it would be community property that belonged equally to W.T. and Chester and their respective spouses. Let's stay there for a second. How many of you actually read your deeds at your closings? Yeah, that's good. Bet your ass you're going to start doing it after hearing all this. Or you just trust me because we've been doing business for a long time, because my law firm creates all of my deeds for my closings. That's another issue. That's another set of circumstances. But you're going to start reading your deeds, whether you're closing with someone that you trust or it's a brand new title company because you didn't want to let the deal go through because it was a killer deal, right? So I want to stop there and ask whether you're reading your deeds because right in the middle of all pages one, is the consideration language. What'd you pay for it? Right? Text is still non-disclosure, so generally it's going to say cash, another good and valuable consideration, unless you borrowed from one of our lenders. They need to secure their interest, so the loans are going to appear in the consideration. Okay? But take a look at the consideration clauses next time. When folks call my office and I want to deed my interest to my son, says Lenny. Okay, well, one of my punch list questions is, what's the consideration? You want public record to say that he paid cash for it, or did you gift it? Yeah, it's always one of my questions. And, hey, do you own the minerals? If you do, you want to keep those interests? Because if you don't reserve them, they go to your conveyance, right? So those are issues that pop up in this case. Mineral, separate, or community property, right? In this state, any property received during marriage is presumed, it's a rebuttable presumption, is presumed to be part of the community, except one of the exceptions is gifts, right? And that's why we're talking about this. If the conveyance instruments, the deeds, said gifts, then the mineral interest would be separate property. If it was for sale, with a cash deed, then it would be part of the community. Both deeds recite that Lilly grants bargain sales, blah, blah, blah. There's that $10 and good and valuable consideration that you see generally on most deeds. Court here declined to go beyond the four corners of the documents and disregards plain language. The deeds were sales for consideration. All right? There was no gift language right there. So, I bet this update omitted a lot of the facts as to why someone would think that it was separate property gift. Maybe their discussions, right? Verbal. Read your deeds. Because if you had a discussion that said, hey, I thought this was going to be a gift, not a sale, then you're changing the nature of the property and what can be done with it in the future. Okay? Look at your deeds. Most of them, like I said, if it's a cash deed, it's going to say cash and good value consideration. But if you don't want it to say that, because you might want to change the characterization of the property or it not to be part of the community, because you don't want your spouse to have partners, then talk to your attorney, read your deeds, make sure it has everything that you want it to have. That's very important.
Or you're a parent and you look like your future daughter-in-law.
Ooh, that sounds like a
Hypothetical, Pam.
Just saying.
It happens.
Mm-hmm.
Not just your deeds, but update your freaking wills. That wasn't a hypothetical that I started the class with. The death in 75. That's a true story. We wouldn't be in this mess if we would have left the will. I promise you that.
So is it better to gift or
That's pretty much
Yeah.
the answer. It depends.
Could you be able
because
to
my
get
son, we're thinking he's fixing to gift me 10.5 acres.
Yeah.
I don't know whether to show I paid $10 for it or it's better to.
Talk to your tax professional, number one. I'm not a tax attorney, but kind of versed in that. Haven't been in business a while. Talk to your tax professional. See what's going to be more advantageous. Talk to your tax professional, your estate planner, all the above. Because it might not be advantageous for you to show that it's a gift as opposed to, no, I paid for it. It's a tax strategy in my eyes at that point. Endeavor Energy v. Trudy. Appellate District out of Eastland as well. Holcomb's agreed to sell a part of their surface estate to the Tom and Trudy Anderson. I don't know if this is a trust or what. Contract provided that Holcomb's would reserve all of the mineral, royalty, and executive rights and interest in their ranch. The general warranty deed that was executed and delivered at closing didn't reserve the minerals.
Uh-oh.
Not yet. Not just the prior case. You're going to read your deeds now because contractually we agreed that the seller is going to reserve the minerals.
Okay.
Who created the deed? Did they read the contract? You know, toot my own horn there. That's why it's nice to have, my firm working conjunctively or working together with the title company because I'm very aware of what's going on. You guys have seen it at other not every title company, but the same, who doesn't have an attorney running it or drawing up the deeds, they'll use the lender's attorney's deeds, right? Are the lender's attorneys going to look at the contract and scrutinize it the way I do? I'm not picking on her, but just because I've seen it. And that specific example I just pointed out is where I see this. The contract says one thing, the deed said something else. Uh-oh. Right?
What takes precedence?
I'm sorry?
What takes precedence?
You tell me.
What they this fine.
I would say the deed.
Let's not get to the conclusion yet, right? But I like the question, so that's why I asked you a question back, so I want you to think about the facts and apply it. He said the deed. Well, to me, where was the intention? What did you bind yourself to? The contract, right? It was a mistake that the deed was drawn to not follow the contract, if that's what you truly intended to do.
Hopefully they have good E&O insurance, right?
Yeah.
Correction?
Hold on. We're gonna get to corrections eventually. I promise you that. All right. See that bottom line? Parties later realized that reservations in the original deed did not sufficiently memorialize and comport with their agreement and intent. Right? You're bound to that contract unless you amended it or did something else. Okay, at some point, Trudy, we'll get to the correction now. At some point, there was a correction attempted where not all the parties to the original instrument were part of it because someone died. Happens, right? So that's why the statute after 2009 property code allows us to make corrections to conveyances. How many of you have heard of 5028 and 5029? A big part of practice since 2009. See, I do those probably monthly. So 5028, you can correct immaterial corrections. Oh, I misspelled Tim's company name, immaterial. Right? I can do the correction. I was a party to the transaction as a closing officer. 5029 is material. We're dealing with minerals right now. That's not non-material. That's a big deal. You're gonna have to go get all of the original parties to the instrument. But what happens if someone dies? There you go. Nicely done. So that's where the facts are going to go on the next page, Tim, on 5. Middle of the left column. For a correction deed making a material correction to be valid and enforceable, 5029 requires that either parties to the original parties to the transaction or their heirs, successors, or assigns have to be a part of it. They have to execute it. So if you can't find someone, or you can't reach someone because they're no longer here, then you go into their heirs. And then it can be an effective correction instrument.
What if the heirs don't want to sign?
Oh, nice. And then bring them, if they're not already part of the suit, then you bring them, and then you get a motion to compel them.
Okay.
Yeah. Because you can't make them unless you have sufficient grounds and facts. Getting a judge to agree with you and say, yeah, I'll authorize this partition and I'll compel them to sign. But in theory, they don't have to do it, okay? Unless you're doing something illegal or holding up a property just because.
So do you have to go and file
Hold on.
Martin, you have to
Hold
go.
on. Let me finish. Bottom of the same section, correction instrument statutes do not define what constitutes substantial compliance. 2009 is not that long ago, right? About 14 years. So these correction statutes aren't that old, and that's why there's not a lot of precedence right now to define what's substantially complying. Okay? So this issue is going to keep coming up, or this topic is going to keep coming up on case law updates. Yes.
Back to Brian's statement, they don't want to sign, and if it is holding up a sale, do you have to go file a petition? Is that what it
Yes,
is?
but you can't make them. You can try to compel a judge, or try to get a judge to sign an order compelling the sale, but you can't just make them to hold them up.
But you can, just not legal. Hire a few guys.
There you go. Yeah, hire Ryan's guys.
There's a seedy part of our group. I know some people. Just let me know.
We'll stick with that column right there. Broadway was a Supreme Court case that dealt with 5029 as well. When the original parties appeared more narrowly, the grantee no longer owned the property at issue. I think we've seen that happen before sometimes. Scrutinize your commitments. Read your commitments too. When title sends out a commitment, read it. Because a lot of times on C, when there's a need for a correction to fix the chain of title, the examiners are going to give you what the requirement is. We need to correct this. We need to correct this legal description. We need to correct the name, whatever it is. Read those. Because, what am I going to look at? Oh, I need to correct this instrument from pre-2009, 1999. Well, it might be that. It might be not findable, right? I don't know what their errors are either. So, issues to look out for. Thus, an heir successor assigned, just like the other cases, required to execute the correction of the original party is not available. There's a trust involved here. It was contending that the correction was, or folks failed to validly execute a correction because they didn't have authority, like we were talking about, and when the correction was signed, he did it only in his individual capacity, as opposed to what as well? Trustee of the trust? Let's stick there. Okay, so we've talked about this quite a bit. And this isn't part of today's case law, but there's a 2019 case, I think we talked about 2 years ago, that is very definitive of a trust not being able to hold title to a property. Right. So,
Would you repeat that?
I'm sorry?
You said a trust cannot hold deed to a property?
Correct.
That's
There you go. The trustee. If your deed, read your
okay.
damn deeds. If
Yeah.
your deed tries to convey to the Tim Cook Trust, it's not a valid conveyance, guys. Not a valid conveyance. If it says Timothy A. Cook as trustee of the Cook Family Trust, valid conveyance, the trustee holds title to the property. I'll pull that case so you can share it with the group too. But all title underwriters follow that now. And read your Schedule C's on your commitments, because not only corrections, but when an examiner finds a deed that's just to the trust, they go, correct it. Is that a 5028 or a 5029 correction?
That's just a couple words
I'd
difference.
argue it's a 5028. You think it's material? If you can prove, I'm talking parties. I mean, this is open for discussion, guys, like I said. I like that.
Well, what do they do?
What do you think?
Is it a material or is it non-material?
That's what I'm inviting discussion on. I don't think it's that material. If you say you can prove the intent of the parties, right, and maybe they didn't have either an attorney or a good one draw it up that's versed in the laws. Okay, mistake. There's an established trustee. My bad. We should have just put the trustee there,
Correction
right?
of the name.
What's that?
Correction of the name.
Which is part of 5028. So I would argue that it is just a name issue. So it's not really material.
It's just a couple of words. What's the big deal?
In this one, I think there's others that it's like, oh, a couple words. Parker v. Jordan, Appellate District out of El Paso,
Where you at here, Martin?
page 6. This involves a gift deed as well, and remainder interest, and I think a life estate, if I remember this one correctly. So let's start with the definition. In Texas, deeds are construed to confer upon the grantee the greatest estate that the terms of the instrument will allow. A deed will pass whatever interest the grantor has, the bundle of sticks theory, right? Whatever interest the grantor has in the land, unless it contains language showing the intention to grant a lesser estate. However, when conveying a future or expectancy interest, an instrument is not given as an assignment, of expectancy unless it clearly manifests intention, there's that word again, intention of the prospective heir to sell, assign, or convey his future interest. This, I'm trying to wrap my mind around these facts as we jump around. Let's just stick here. Y'all know what a remainder interest is? We don't see them often anymore.
Yes, on the life estate.
That's an example of one.
That's
So what's the remainder interest in the life estate?
That's when a person passes, whoever gonna be entitled after they pass.
Uh-huh. Yeah. That's the reversionary interest, right? I like Tim. I'm gonna give him a life estate in my property, but his heirs aren't gonna own it after he passes before me. It's mine, right?
For the remainder of it.
That's it. So there's two other primary examples. I think we'll get into those either in this one or another one. Fee simple, determinable, or fee simple subject to condition subsequent. And those two concepts right there will determine who the remainder man is and how the remainder man can get title to the property again. Okay? Keep that in mind.
So give me the example of a remainder scenario again.
Well, she brought up life estate, and that's one example. So I give you a life estate in one of my properties. You can enjoy it. You can live there for the rest of your life. Should you pass before me, it reverts automatically back to me.
So it's mine
For life. To enjoy and use.
Yep.
But not to sell.
But when I die,
It depends. I'll get back to that. Go ahead.
when I die, it goes back to you.
Yep.
I pay for taxes, maintenance, all that.
You're going to enjoy it. That's right.
Yeah. Oh, you wouldn't take care of that for me?
He said, did you say you can sell or can't sell?
I said, but not to sell. If it's going to revert back to you, then he can use it and enjoy it, but
Yeah.
not sell.
Guess what? I've seen life estate deeds that omit that language. So Tim, the crooked guy, is going to go sell it from underneath me. I'm like, whoa, right? And that's why you close with title companies, because the title company will find that deed and say, hey, Tim, you can't sell this without Martin's authorization, even if it doesn't have that language. But yes, a well-crafted life estate deed is going to say, I give life estate to my in-laws because they're over 65 and it gives me tax breaks on that house that they live in, right? So I gave them a life estate, but are they allowed to sell that without my authority? No. Am I? Yeah. I want to.
I just saw it as a business opportunity to make some money. You gave it to
There you
me.
go. Yeah, right?
You didn't put the language in it,
You
so
think
I
that's
sold it.
happened before? Yeah. I'm sure that's in the
Okay.
law.
Life
Sure that's in the law
estate,
book somewhere.
they can go and get their over 65 exemption, which is the life estate.
100%.
Nice.
Yeah.
And he can
That's-
get,
that's right.
get
Yeah.
loans
But
based
Martin-
on life expectancy, right? They can get a
Well,
loan
that's a
against
question
the
for
life
you,
estate.
Martin, you said you could sell it if you wanted to, but wouldn't that be, I mean, the
I
people
get
that.
power of sell.
Right, but sell it while they still have their life estate, would that bind the person you sold it to let them continue to live there until they die?
Good question, because a lot of the concepts we're talking about today, guys, run with the land.
Yeah.
Right? They run with the land. Talk covenants here in a little bit. But that doesn't run with the land. That's contractual between my life estate holders and me,
Right.
not someone who's going to sell. So stick with that. Even though I have the power of sell, would any title company allow me to sell by itself? A bad one.
I would hope not.
Right? If they don't read it. Right? But if I was in that scenario, that doesn't involve my property, I'd go and get those occupants that have life estate and say, hey, will you basically sign a deed or release your life estate so my new owner doesn't have issues in the future? Because they're not bound to honor a life estate.
So, sorry,
You
Lexi.
have the right to sell it,
I have the power of sell.
even though you give him
Even though
line. Before he died, you go and sell it from under him.
that's my property, so I would not be able to. I want the power to sell. Mortgage it if I want to. Right? But then
What-
In other words, he's
Hold on.
declaring
What
Tim
other
legally
company's
dead.
Hold on, one at a time. What are their companies going to do when I try to mortgage a property that has a life estate? Martin, you're gonna feed it back to yourself because you're my borrower, not Tim, right? I would suspect your underwriting counsel would require that.
So
Lots of
let's
things to consider.
Who's the
there.
actual
let's take
owner?
that in the reverse though. What you deeded to me, the life estate, and I go put debt on it, take out a mortgage just before I die, and then you get.
My example.
Huh?
I didn't give you the authority to. I just gave you life estate. You have no right to mortgage,
Okay.
sell, or anything.
What happens if you die before he does?
Do I have a will? Is my first question. Right? Because if I don't have a will, then my interest goes to my heirs at law. So I'm going to go on those routes. We'll do that.
So Tim's not actually the deed owner.
Last one here, and then we can move on. What?
Tim wouldn't actually be a deed owner of that. You're still the owner of the deed.
It's an interest in the property, but what did we say earlier in that last case we just talked about? To the furthest extent possible, I didn't intend to give Tim anything besides a life estate. He can't mortgage it. He can't sell it. He can't really do anything besides use it, enjoy it, and live in it until he dies.
That's what I wanted you to say. So everybody heard that. So.
That's right. Okay, let's go to page 7, Thompson versus Six Shoe, also appellate court in El Paso. A conveyance of an interest in real property must be in writing, must be signed by the grantor, and must be delivered to the grantee. Have y'all ever heard those 3 requirements? That's it. A conveyance of an interest in real property must be in writing, be signed by the grantor, and be delivered to the grantee. What's the first question that comes to mind then? What?
Was it recorded?
We'll get there. But that's that.
What's the delivery?
Delivery? Well, the grantee needs to know at some point, right? Because that's the question I get sometimes. Wait, someone can give me property and I don't have to sign anything? Well, yeah. It just says the grantor's signature. It doesn't say anything about you accepting it. But that's why there's a delivery requirement. Right? I think that was part of last year's. There was a delivery issue in last year's case law update. Okay, so those are the elements. Writing, grantor signature, and delivery. In Texas, it's also settled that title to real property will vest upon execution and delivery of the deed. Execution and delivery? Title vest already? Interesting. What about recording? Recording doesn't make a deed valid. What does recording essentially do?
Public knowledge.
Thank you. It's called constructive knowledge. All of you right in this room are constructively aware that I own the property that I own because it's recorded in the deed records. Okay?
So Martin, if I deed my house to my daughter and it's not delivered to her, notice is not delivered to her,
Mhm.
then she doesn't know.
That's the one that I think I remember from last year's case law update. Does she? Well, if you just base it off of the 3 elements, probably not. It was never delivered. So on that one, if I remember correctly, it was deemed delivered for some odd technicality in that grantor, you, told your daughter where you keep all of your testamentary documents. And in that safe was a will, was a trust, was the deed. By virtue of you telling her where you keep your documents, it was like a constructive delivery. Yeah.
Well, just weird example here, but
Yeah, that issue's come up before. In my real practice too.
Yeah.
So I'm going to stick with recording real quick because what am I at the end of the day? A title attorney, right? We want instruments recorded. And we want them recorded right away. Well, Texas Department of Insurance makes them record them within 2-3 days after closing, not before. But what if I run into a chain of title that has an unrecorded deed that affects title of the property because it was delivered, but just not recorded? What happens there? That's why you get title insurance, folks. How am I supposed to find something that's unrecorded but it's valid? You can't put me on the hook for that. Read your title commitment. In the exceptions section, section B, talks about unrecorded instruments. And one more on that topic. Leases. A lot of you guys have rentals in here. Leases aren't recorded. How am I supposed to know about them? If in the contract, I know Tim does it, if in the contract you don't put that this property is subject to leases, how the hell am I supposed to know that someone else besides the owner lives in there? I'm not on the hook for it. That's an exception to my policy. So Tim sells a house to me, doesn't tell me about the lease, title doesn't know about it. I go and start to fix it up. Oh, someone's in there. And they say, stick it in your ear, Martin. I live here. I can't just kick him out unless I call Ryan and his resources. I have to do a forcible detainer. Right? Yeah.
Is that an asset protection then? If you just deed it, deliver it to somebody else, your children or something, someone tries to come after you, you don't own the property.
Yeah. For the most part, when I see that in practice, yes. But just think about if you're doing it to avoid creditors, it's a no-no. Laws say that could potentially be avoidable. But yes, asset protection.
Liability.
Yeah.
So,
That one back here.
Sorry.
So if you had somebody that was in there that was leasing the property, you were unaware of it.
Yeah.
The court wouldn't give them any, like, hey, you've got a lease. Now,
Well, now
enforce the
you're
way-
introducing new facts. If there's a valid lease, what's
Yeah.
the answer?
I'd
They
say
have the
the-
right to stay in the
stay
house
Yeah.
for the remainder of the lease. It's not a claim on your policy. It's an exception. I don't know about the lease. You didn't tell me.
Right.
But they absolutely have the right to honor the rest of their lease and stay there throughout. And the new owner is going to have to. And what's that new owner going to do? Sue Tim for not telling about the lease. Careful buying stuff sight unseen. Seen it happen.
Is
Not
that
kidding.
in Texas? Because some places I've been stationed at, if you don't record your lease, the owner can sell it and break the lease.
What did I say earlier? I'm only licensed in Texas.
Okay, I just wanted to make sure.
Yeah. I don't practice anywhere outside of the state. I don't really care to.
But in Texas, if there's a lease, you have to uphold it when you buy the property.
If it's a valid lease, it survives the
Okay.
conveyance. Absolutely.
If someone puts a property in a trust, since we were talking about
Whoa, just the trust?
trustee,
There you go.
do they lose their over 65 exemption?
No, you can still get it. The appraisal district's going to say, hey, reapply, right? But yeah, you can still have it. So let's go back to my in-laws example. So I recently created a trust, right? Katie and I are trustees. So when I went to reconvey the property that her parents live in, I conveyed it to us two as the trustees of the trust, family trust. But I also recited in it, in the deed, that the life estate still survives. They can't sell it. I have power to sell. So the appraisal district read the deed, and they did a good job. They still show them. They can still have their over 65. But technically now me as a trustee of the family trust is the fee owner subject to a life estate. Yeah. So the trust isn't going to affect whether or not you can get your exemptions. It depends on possession, who lives there, and what qualifications might be met by the person who is occupying pursuant to a life estate.
so another scenario I think everybody should hear the answer to is if you've got a property in a trust with a trustee, and for asset protection purposes, or for even a need happens that you need to change the trustee, you do that new deed, but that new deed does not have to be filed on public records, correct?
What did you say earlier? It doesn't have to be filed to be effective.
And that can't be construed as any kind of illegal attempt to avoid or hide or, I mean, it's asset protection. I mean, it's so easy. Anybody can be sued for anything.
Sure.
So if you're trying to take the true owner, which is the trustee, off public records, then they go to public records and see the original trustee, but you show up at closing with a deed with a different trustee, that's not an issue in your.
Well, now that last fact that you introduced will create an issue in my world because nothing that you said is illegal or going to break any laws. However, guys, title companies are risk takers. Once I hear that and I introduce the fact that there's an unrecorded deed in this chain, ouch, I'm going to pump the brakes. I'm going to hold the sale up until I find more out, right? Even if you were doing something that you were able to, because I'm insuring buyers and they're bona fide purchasers because they don't have any constructive notice that deed exists. And I didn't either until you just told me, and I'm like, whoa, okay, right? And at that time, time, if we were to continue that transaction, I'd tell you, give it to me because I'm going to record it before we record a deed to you buyer.
That I wouldn't think that anybody doing deals in land trust would have an issue with that. If they submitted that deed with the contract.
Right. That's the cleanest way possible.
Yeah. No, that makes sense. But for anybody that's doing stuff in land trust and asset protection,
There's someone that used to be a part of this group that probably does exactly like you do, that sends me everything up front, including the deed that you just read. Yes.
Can you reassign the beneficiary without changing the trustee and everything continues okay?
If the trustee has the power to, sure. What's keeping the trustee from changing the beneficiary of the trust? Just keep in mind trust laws. Trusts fail when the same person's the settlor or the person putting the property in a trust, the trustee and the beneficiary. I've seen that happen before. Let's see if we're going to stick with Thompson. Good discussions. Thank you, by the way. Although equitable title, still on 7, to real property passes at the time the deed is delivered, a delay in recording the deed leaves open the possibility that the prior owner can illegally purport to convey the same property to a different purchaser. That happens. Seen that too. So, not entirely in line with what Tim said, but always keep in mind you have the ability to hold the deed in trust and not record it, but a delay is going to not only affect constructive notice, but the ability for the crook to sell to somebody else out from underneath that unrecorded deed. So, Texas law settles disputes like that over competing deeds in favor of the first to record. So, if you're holding a deed, you better watch out with who is the grantee of record, because if the grantee of record then sells to a bona fide purchaser that has no clue about the deed you're holding, then they would probably win at the end of the day, especially if they have a title policy. The title underwriter is going to go and have to defend that bona fide purchaser that had no clue about the deed that was being held. Now, that doesn't excuse the seller who's selling to multiple people, but the purchaser is protected, especially with the title policy. So things like that are handled. Same paragraph, that's what's called bona fide purchaser for value.
So Mark, going back to that scenario. So if I am the beneficial interest and I send notice to that trustee that the trustee is terminated, and we've assigned the new trustee and we have that new deed, and then he turns around, the old trustee then turns around and sells it, the fact that you have notice that he was terminated, you have legal grounds to go file suit against him, right?
Sure. Well, I was saying that the seller's not excusing my hypothetical and the ex-trustee's not excusing your hypothetical, but that still doesn't change the fact that the bona fide purchaser for value is protected because he or she had no clue about the unrecorded instrument. So, it's, on that note, too, it's up to you whether you're going to record your trust. Trusts have a lot of personal items in there and things you don't want in the public record, so the statute protects you there, too, the estate's code, allowing title or whoever to create a certification of trust, 2-page instrument that just talks about the trust still in effect, hasn't changed, et cetera, just so you don't have your personal info out in the public record. But back to where I was going there is not everybody records trust, and not everybody records revocations or terminations. So it's an interesting fact pattern. But if I don't want to record my trust, but I want to record termination so everybody knows that that trustee is no longer a part of this, I would record certification of trust alongside with it, but right before termination. I think that's the best way to go there. Yes, I'm not there.
I was just going to say I didn't think that certification of trust was something that was used in Texas.
Oh, it is.
Do you see it a lot?
It protects third parties like me that say, hey, Lenny, I don't know that you're the trustee of this trust. Prove it. Lenny says, well, I'm not going to send you this trust. These are real conversations that we have. My trust is 250 pages. You really want me to send that whole thing to you? Well, yeah. But if they say no, then the third party is protected by executing a certification of trust. That satisfies the requirement of me not being able to get what I need for closing.
Would you, so, we don't allow that.
You don't allow what?
We require the formal trust.
Yeah, but statute's pretty clear that if someone's gonna, I try, but I'm not gonna get a mismatch with them. All right, you don't want to show it to me, fine. You're signing a certification that I'm creating, not anybody else.
We won't blend that situation.
I'm not the first one to ever say that. Yeah, you're more at risk there than I am.
Sure.
You show me yours and I'll show you mine.
Yeah, there you go. Weapons. So we've talked about these concepts, but we'll just leave this one with the right side here. We talked about the bona fide purchaser. It's in Chapter 13 of the Property Code. To receive that protection, the buyer can't have actual or constructive knowledge of those unrecorded instruments of the prior conveyance at the time of purchase. Constructive notice is notice that the law imputes to a person who does not have actual notice. A recorded deed is one instance where notice of the conveyance is imputed to a subsequent purchaser. Let's go to 11 and talk some easements. Anybody ever deal with easement issues?
Frequently.
Frequently? Yeah, I'm not surprised. Where do easements show up in my title commitment?
We got a survey, Schedule B.
B. What's Schedule B again? Exceptions. That'll cover it. Read your title commitments. If you need an instrument that affects your property, title should be able to send it to you. Easements are going to show up on Schedule B. Okay? If you don't deal with them often, you'll start seeing why these are such big issues, why their exceptions not covered by the policy, and why they're subject to lawsuits. This one's here, Appellate District out of Fort Worth. Great court, in my opinion. Avila's neighbors erected a barrier blocking his only means of access to the property. Cool. Great. Is that legal? Well, I guess it is. That's the wrong question. Yeah, she did it. But can she get away with it?
Not very neighborly.
Not very neighborly. You can't restrict someone's access to your property. Right? That's where this case is going. What's that called? An easement by necessity. I can't get to my property. You have the lawful right to. All right? Easement by necessity is
Only if there's an easement, right? If they bought a landlocked property,
right.
You have to use this property.
You'd have to go and find the parties that can be part of the easement to make it effective and plead necessity. I need to access this. I should be a part of that. The survey showed that it was going to be landlocked after conveyance. No easement was done. Well, you bet your ass I did an easement before we closed, just so I'm not part of the lawsuit in the future. Yeah. Yeah, obviously Avila sued, won a necessity easement to cross the land so Avila could access his. On appeal, the neighbors challenged the necessity easement. On cross, Avila said trial court implied determination that he did not have an express easement, which is different than an implied or necessity easement. Whether a property owner is entitled to an easement by necessity is a question of law, although underlying factual issues may need to be resolved in order to reach the legal question. Where an owner of a single area of land conveys away part of it, the circumstances attending the conveyance may themselves, without the aid of language in the deed, which you're going to start reading, right? And indeed, sometimes in spite of such language, cause an easement to arise as between the two parcels created. The landlocked issue is the most popular example of that. Okay. You convey your new bona fide purchaser that I insured doesn't have access to the property, we'll get an issue. We're going to have to create one. Okay, if one's not created because the parties aren't cooperative, you sue. You get the judge to agree that you have an easement by necessity. To successfully assert a necessity easement, you have to show unity of ownership of the dominant and servient estates. Claimed access remains a necessity and not a mere convenience. If you just don't like the road that you have to access your property. Oh, you don't meet element number 2, get out of my courthouse. And the necessity also existed at the time the estates were severed, like the one that I told you about. So when it's unique ownership between you and yourself, no. But then if you parse a piece off of your land and sell to someone and they don't have access to it, well, that's where number 3 comes into play, right? Necessity existed at the time that the estates were severed. Go to 12. Go ahead.
On the easement thing, I know I had got a property at a tax sale one time, and
Oh, that's so weird.
yeah, and then they it used to have water coming from the main, I don't know if it's Serbian or what kind of state.
Dominant or
Dominant.
serving, yeah.
Okay.
So you know the distinction there?
Dominant is who's the main one.
That is receiving the benefit.
Oh, okay, so it's Serbian. So it
Well,
just
go
was
ahead,
in the back and by the alley and stuff, and so I tried to get water and stuff on. I couldn't because the water meter was in the front, in Sylvania, and couldn't get it to the back. So I still don't have water there. But anyway, but it cut off if they couldn't cross over. That the water company couldn't no longer service that because it was severed. So
Yeah, I can't remember if you brought that to my attention. I had one just like that.
So would that be a by necessity, because the necessity for water existed when the.
Is there no way that you can access it, or is it just a mere inconvenience for you?
No, because it would take a lot of money. I got a quote for $50,000 to
Oh.
get water there through the alley, because you can't, TCEQ and everybody else. So it was interesting. So that's a necessity if because I contacted the front people, and then they was like they didn't want to, do anything.
I would advise suing. It's not going to cost $50,000 with the bank, and then they have to answer. And you can say, hey, I tried to get you to get an easement with me. Let's meet at my lawyer's office. It'll be much less than $50,000.
But you'd have water.
Water. You're welcome. What did Tim's slide say? Oh, God.
Sorry.
It's okay. I don't know if I'm going to do Cowan. Target's a good one. Go to 13. Yeah, there's some good ones out of the appellate district of Houston. They have two, by the way. That's why you see 14th district right after Houston. Okay. Lots of parties here. Eventually, Target Corporation ends up owning the land in question. What does Target do? Build a huge supercenter. What else do they do? Parking, etc., etc. So there was an environmental parcel at issue here, okay? And there was a question as to who owned the environmental parcel, because at some point the entire tract was parsed off, okay? And there was an easement recorded of record at some point that said it was perpetual and non-exclusive use over the environmental parcel. So you can probably see where this is going. The environmental parcel is the part of the tract that was eventually paved for parking, okay? At one point, the alleged owner of the environmental parcel then erected a fence that ended up prohibiting or inhibiting Target from using the parking for their intended use. Target, of course, sued. At that point, the D&H, among 14 now, owned the property. Target sued. They wanted injunctive relief and damages for breach of the use easement that was in the title record and runs with the law. Right? Target said, I should be able to still use this. Because easements are real property interests, easement agreements are subject to the statute of frauds. What's the cardinal rule of the statute of frauds? Things have to be in writing. 12-point font, at least, I forgot what the language is. It can't be in a font that is misleading or unreadable, right? Let's see what I want to extract from this case before we move. An easement in which the benefits are for specific parcel of land, regardless of the identity of the owner, are easements pertinent. Okay. At the time of conveyance, use easement was, in this case, an easement appurtenant belonging to a prior owner, which is Woodland Heights. Then the easement passed to another owner, Sawyer Heights, through express language in the deed. You guys are going to start reading. Unless there are reservations or exceptions, reducing the estate conveyed. We mentioned consideration clauses in the deeds earlier, but the other sections are exceptions and reservations. Right? One of the deeds said that the conveyance is subject to the items listed in permitted exceptions. Not all the time do I see permitted exceptions put in a deed, right? That you'd see in that schedule B. Some people aren't practicing doing that, right? It'd be more specific to show intent on what the permitted use of the property is going to be after the conveyance. And if you include exceptions, then it's going to help determine the outcome of this case. So at D&H asserted that one of the deeds accepted to the use easement, meaning that Woodland Heights prior at that time retained the easement and did not convey it with the dominant tract. The court there disagreed. So by including the easement agreement in permitted exceptions, Woodland Heights notified Sawyer Heights that the dominant tract was burdened by the access easement. The trial court also determined that there was a taxable foreclosure chain title, extinguished the option. Not an issue there. However, what we're extracting here is in the deed, if permitted exceptions are placed there, it's what? Court of record, everyone's on notice, and it burns the land or runs with it, depending on whether you're the owner of the dominant estate or the servant. Okay. Evictions are a huge part of my practice right now. Let's go to leases and evictions. Starts at the bottom of 14. Big part of y'all's lives right now too, especially you all that own rentals. Harris versus Harris. This one has to deal with Section 8, federal regulations. Federal regulations state that no termination, of a tenancy in a federally subsidized project is valid unless notice is provided to the tenant detailing the reasons for the eviction with enough specificity, and probably the font too, not probably, definitely, so as to enable the tenant to provide a defense. You can't just try to pull a fast one. You got to follow the statute. What am I going to recommend there? Hire an attorney at the very beginning. Don't try to do notices yourself, even if you know what you're doing. I mean, that's always going to be my opinion. I was in JP8 last week. I saw a real estate investor agent. He goes almost weekly, so he knows what he's doing. But other than that, you have to follow statutes to a T. So that's why we start with, hey, was your notice valid? Whether it's federally funded or not, is your notice valid? Because guess what? You don't want to get to the finish line and then a judge says, well, show me your notice to vacate. Oh, okay, you presented one, cool. Did you follow the statute? Get out of here. You didn't. Try again. I've had some clients have to call me in the back and say, hey, this happened. Well, you should have called me first, man. True stories. Termination notices for back to federally subsidized housing have been found to be insufficient where they contain only one sentence. Seriously? So that's what it said. Get out. Is that valid? Go. It's fine. Your time has come. Insufficient where they contain only one sentence are framed in vague and conclusory language. You can't just say, hey, you've defaulted. Who are you to say that? Hell, even I can't say that. That's for a judge to rule. I'm just going to say, pursuant to the lease, you need to leave in 3 days or 10 days if you want to cover attorney's fees, or else. Right? And then you file. Go to the next one. SH Salon and Market. This one's interesting. It got me. I don't necessarily agree with the entire ruling, but it's forum selection. You guys know what forum selection is? It's basically picking where you want to adjudicate the matter. It's picking in court. Yeah. Now, is forum selection legal? Yeah, to an extent, right? So this one's interesting because the lease did not say that, and we're still in Houston, the lease did not say that you're going to go to Harris County Court. The lease said you're going to go up to New York, and New York laws are going to govern this commercial lease.
Oh my God, wow.
Especially if you're in the commercial space, guys. Definitely get an attorney to review that lease. I bet they didn't. And they just signed. When it gets lost in the allure of the excitement of a new project. Oh, you signed a lease that said you're bound by a forum selection clause that says you're going to adjudicate in New York if shit hits the fan. What? That's exactly what happened. Lease included forum selections in New York, including waiver of all objections to venue based on the clause. A waiver? You're waiving your right to adjudicate here in Texas? Can they do that? Yeah, they just did. Sucks for you. You know, the whole, hey, I didn't agree to that on your phone bill. Well, yeah, you did. You didn't agree to phone bill either, right? That's sort of analogy that I think about here. Right? I didn't waive it. Well, yeah. I mean, we keep talking about the 4 points. What did you sign? So long as the lease is legal and valid, you just bound yourself to that. So what was their entire argument? Hey, commercial tenant. Well, everybody that I bring to put on testimony and be a part of my claims and my assertions, they all live here in Houston, Harris County, and the surrounding counties. Who do you think the judge said?
Well, I do.
Too bad. Too bad. Under Texas laws, courts look at the factual allegations and the claims when deciding whether the claims are encompassed by forum selection. Forum selection are generally enforceable, and there was a presumption that the clause here is valid. As opponent of the presumption, the tenant had a heavy burden, right? And that's why, yeah, you want to do it here in Houston, you got to prove it to them. Here are the elements. That enforcement of the forum selection clause, we want to 16 here, would be unreasonable or unjust. The clause is invalid for reasons of fraud or overreaching. Right, so it has to be legal. You can't put a forum selection clause that would probably constitute fraud. Enforcement would contravene a strong public policy of the forum where the suit was brought, or the selected forum would be seriously inconvenient for trial. We're talking about mere inconveniences, right? They'll follow a recent case here in Fort Worth too. Lawyers tried to remove the case from here because I can't do anything here when there's so much media attention, right? They tried to move forum, okay? So those are the 4 elements right there. When, as here, a party could have foreseen at the time of contracting, and at least before you sign, the inconvenience of having to litigate a claim in a foreign forum, even if it's New York and you're in Houston, the party cannot escape the contract's clause unless the party shows that trial in the contractual forum, New York, will be so gravely difficult and inconvenient that the party will, for all practical purposes, be deprived of its day in court. The judge disagreed. Said, you want your day? Get your ass up to New York. That's what you signed off on. We'll go to Adams, same page 16. Another eviction. Got my mind around this one. Anybody in the commercial space? Yeah. You ever done any commercial evictions? I had to be a part of one. A lot more intricate than residential. Let's see what I want to
It's
extract
still
from here.
governed by the property code, right?
Oh, yeah.
Commercial.
Oh, yeah. Now, if there was some commercial residential difference, I wanted to extract from this one here. but I don't want to talk about bonds and whatnot, but I can, I guess. So in the commercial space, bonds have to be set, or sometimes they're set based on the value of the property, right? Especially if you're going to appeal. Well, let's just say it's residential too. Either way, when you appeal a justice of the peace decision, where do you go? Remember? County court of law. Yeah, yeah. So they're gonna make you put up a bond, right? That's much more than the justice of the peace court would. And what the facts led to us here is whether or not, this one made it to the Supreme Court, I think, whether or not when the landlord asked that the bond proceeds be released to him because he was so burdened by the appeal and it dragging so long, whether or not that was appropriate or whether the court that released the bond was abusing its discretion.
They wanted to release it to the person that put it up or the landlord?
What's the reason for the court having the tenant put a bond? Why?
Frivolous appeals.
Yeah, it's protecting the landlord from losing so much more than what has already been lost during the appeal process. There's no guarantee that the appeal is going to happen right away. What if it drags? Which is very common right now. Yeah. So there's a lot of facts that we're omitting in our discussion here. So we could be here all day, but the one that I wanted to extract is when the plaintiffs, whether or not they pled it in trial or appeal, whether they're entitled to the entire bond, which the court released to them, which the Supreme Court ended up saying you're using your discretion, because you guys have heard the old, maybe not, if you don't raise it, you waive it. You better raise it in your pleadings. You better ask for it if you think you're going to want it eventually, right? And that's what I wanted to emphasize here, especially if you're in a commercial context. Go ahead.
So after the judge say, hey, we grant you possession, so they gonna write a order, a judgment or whatever, and then after that, that's when the landlord petitions for the money that's in the registry.
Right.
The bond.
Yeah.
So what happened in the case? What didn't happen? How
So
was he being abusive?
No. The court abused its discretion in releasing the entire bond, which is like almost $200,000 to the landlord, right? So when the court abuses its discretion, what does the Supreme Court say to the trial court? You're going to have to go and remeasure how much the landlord is actually entitled to. You can't just say, here's the bond. That's where that case goes.
Did he have to give the money back to the court then?
It goes back to the registry. When the case is remanded from Supreme back to the trial court level, go back to the registry, and then while the trial court figures out a just and equitable, he's not going to get hosed, right? But he didn't need it all either, right? It's just there to protect the event that the appeal is going to not just inconvenience, but injure probably the landlord even more than it is.
I'm thinking about residential like this because it's like the month of rent. They normally set it at a month of rent.
Right, that's right.
Whoever said it at 200,000 because it was a commercial.
Yeah, and that's why I led with the value, right? So that's where the bond was. Mm-hmm.
So the amount of the bond is huge.
Yeah. Oh, lovely HOAs. They didn't do this one. You guys want
3 liter, 4 liter word.
Yeah. And restricted covenants too. I know you guys have rentals, verbals, or STRs, short-term rentals. Figured. We will, we'll stick here then. Jay Rice.
Have you been following the HOA thing up in North Vinton?
Yeah. I've got clients that own property with. So I'm not used to it.
Oh, okay, gotcha.
Say that one more time.
What's that?
What did you just say?
I have clients that own properties in that subdivision in question intent, and so I can't speak to it.
heard that the state, the state is gonna start controlling the HOA.
Can I ask a question?
So they're petitioning for it.
We'll see what happens this session, right?
Can I ask a question on HOA though? Real quick.
Make it quick.
All right, so I want to know, about my HOA is my personal home. I keep getting a violation for my neighbors, right? They send it to the wrong address, the pictures and everything. So I reached out to them and sent them an email and said, hey, I am disputing this charge of violation.
Yeah.
And they keep sending me letters, and I haven't got it straightened out yet.
So they're sending you the violations when it's
Yes,
actually a
and it's
neighboring
actually my
property,
neighbor. Yes.
not you.
And you know, they just come out and take pictures of whatever the violation is, and they keep sending them to me. I just got another one maybe 2 days ago, but I reached out to them and said, you guys got the wrong address.
Mhm.
I want to make sure this is coming off my record or, my HOA or
Yeah,
whatever.
you don't want them blowing back up.
Yeah.
This is for everybody. This is a good discussion. Part of section Schedule B of your commitment is going to have your covenants, conditions, and restrictions.
Right.
Right? And a lot of covenants, conditions, and restrictions establish a lien on your property right away.
Right, exactly.
Right? So yeah, you want to protect yourself because there is already a lien, and if these violations aren't really yours, then
Yes.
they're going to start filing some stuff in your chain of title that's going to say, "Oh, you owe me." Yeah.
So I guess they sent me a couple it's certified by mail. You know, you don't sign for them, but they just come and there's a letter
Of course, I send
saying,
those
talking
all
about in my deed or my title, this is a violation of blah, blah, blah. And then there's pictures attached to it, but I sent them an email and I was like, look, this is the wrong property. I'm disputing
So what's your
this.
question?
Huh?
What's your question?
Do I continue to, I just got another letter. Do I continue to make sure do I send another letter? Continue to make sure they delete this from my record? I told them the wrong, they sent me an email and said, I'm out of the office, I'll be back on Tuesday. I think someone tried to call me.
Yeah.
I missed their call, but I reached back out again, but I'm about, should I send another letter? Because I just got, so I'm keeping all of them, dating them when I got them. I'm going to scan them and I'm going to send them back. I'm thinking I should send them back to them again. Saying, hey, make sure you remove this from my record. You got the wrong address again. And it's my neighbor next to me.
Or should she just hire you to write them a letter?
Ham known me for a while. That's my answer.
And it will
Because
go away.
I'm legitimately afraid that they might be filing things in your.
Yes, that's
But they might be filings in the chain of title that's affecting your property. And why did I bring up the lien earlier? A lot of these covenants, conditions, and restrictions allow foreclosure of those liens. You don't want to go down that rabbit hole, even if they're making a mistake.
Right. Yes.
Yeah, of course.
So.
And if it's your homestead, that would this HOA companies do. If it's your homestead and they're improperly encumbering by filing liens, shame on them. There are a lot of remedies there.
But they're not acknowledging your emails, right?
So yeah, that's what I'm at. Is it a property management or is it just a
The property management, I guess, HOA, yeah.
So, and they're not responding to you
I
at all?
think
Do
it's
they
principal.
ever?
I think it's principal management. Well, it was around the holiday when I got it. I'm like,
all right, now that you named who it is,
I'm
not
sorry.
gonna speak to it. That's
Okay,
all
I'm sorry.
right. Gotcha.
Sorry. Well, somebody asked me today, so sorry. I won't say that. Okay. Sorry.
Okay, is this the SFR one? No, that was later. Or SDR rather.
Where we at, Martin?
18. Okay. Yeah, this one's good. All right. Jay Bryce purchased 2 townhomes in Willcrest. Started offering the townhomes for lease on a vacation website. Townhomes are subject to neighborhood deed covenants that we keep talking about, covenants, conditions, restrictions. The covenants empower Willcrest to enforce the covenants and otherwise govern the community. One of the covenants governs leasing activity. Leases must be in writing, and tenants must comply with the neighborhood covenants. This covenant, however, this is where the case is going, limits additional restraints on an owner's right to lease. Limits restraints on an owner's right to lease. If the HOA shoot this up in the foot right there. A leasing restriction must be found within the covenants or in the association's governing docs. Otherwise, there is no restriction on leasing. Okay. If you run an HOA, an attorney draw up his covenants for you. Another covenant limits townhome occupancy to private single-family residences for the owner, his family, guests, and tenants, and it forbids commercial uses. So J. Bryce observed that neither the residential use clause nor any other covenant limits an owner's right to rent his property for minimum duration. The association, on the other hand, said, hey, you breached the residential use provision by putting it on this vacation website, and said, what else? What happens with short terms? Nuisance, parties, etc. Yeah, noise complaints. So that's what the association
Not
is.
my clients.
Not your, not your clients, you personally, Dan. Shoot. Okay, so what did the trial court say? Trial court granted partial summary judgment to the association. They said that J. Bryce violated residential use restriction. There was an evidentiary hearing where the court enjoined Bryce from leasing townhomes for periods of fewer than 7 days. All right. Court of Appeals affirmed on different grounds. So the property code authorized the association to adopt rules banning short-term rentals. Because the governing documents are silent as to the specific duration of any lease. That's what the Court of Appeals did. Defining restricted covenants. The contracts that run with the land and are subject to the general rules of contract construction. Stay there. I'm not going to tell you to read them because I bought an HOA and I read about half of them. Covenants, conditions, and restrictions. So peruse them. You're not going to read them all. And make sure that you're not bound to something that's going to prohibit you from using the property for your intended use. Right? It's an exception to the title policy, so you can't come back and make a claim with me. And unfortunately, the HOA, within legal rights, can enforce and will. I get weekly emails from my legal website. Should I get this to me? Well, you're probably bound by the covenants.
Can you dispute though? I mean, what can you dispute? You said you use it for your own use. I mean, what on those covenants can you dispute in a HOA? You can't, can you? You mean before you someone you agree to them? I mean.
Yeah, that's why I'm saying
okay.
read them
Okay.
because you're bound by them.
Okay, you said make sure that's something you willing to accept. Okay.
Because if something prohibits your intended use of the property,
Yes. Okay. I heard something else. Okay.
So I want to. So Great Prairie allows STRs, short-term rentals. But if there's a subdivision as an HOA, and in that HOA, it says no STRs allowed. That HOA overrides what, even though Grand Prairie allows STRs, correct?
I wouldn't say that an HOA is going to override a city because we're going to talk about zoning at the very end and STRs. Did you see what happened in Arlington? That's what that last case is about. So the city came in and said, we Cowboys, Rangers, everybody's there, Texas Slide.
Yeah.
So I'm out of Grand Prairie, this was the last case again. Arlington came in and said, you can have STRs here, but they basically mapped their own zone where you can have STRs, and if you're outside of that zone, sucks for you. So that's why I'm not just going to say, yeah, it's overrides. Yeah, you're subject to those covenants, so we're going to take what those covenants say, and then we're going to see what the Planning and Zoning Commission said about your STR, and then we're going to come to a conclusion on what can I do or what's prohibited. Yeah.
Just a really quick point. So if I were to buy a property and the covenants change,
Yeah.
I'm still bound by when I bought it, correct? Not a change.
So sometimes you can be grandfathered in, yeah. That's not an across the board, and that's why I always want to, let's not get too conclusive. Let's discuss, right? Because, yeah, sometimes you can be grandfathered in. That happens. But depending on what the covenants say, I think there's one that we might or might not go over today, where the court said, hey, if you want to change the covenants, I just found a part of your covenants that say 75% of the ownership can come to an agreement, sign something off, and can change it. And then you're bound by said change, right? So it's going to depend on what your covenants allow and what type of changes are allowed, or if you can be grandfathered to what covenants were of record running with the land when you acquired the property.
Has anybody come across an HOA that does not allow single-family rental at all?
one in my, one in the neighborhood, I think they live off, it's in Fort Worth. I don't know if they're HOA, but they had a meeting and agreed there would be no short-term rentals.
I'm
You
talking about
saying
just
single
regular
family
rental,
long-term?
just single family rental property.
Yeah, it's of the single family now. But they said home daughter, you couldn't, in some areas you cannot do any rentals at all. You can still own in some of the HOA.
Yeah.
Mine has a restriction,
Huh?
I read it 3 years ago now, I can't
Is that-
recall, but it might be like, no, I'm not gonna say it. I'll read it and I'll tell you, but we allow it subject to some parameters.
I was just curious if there was any out there that don't allow rentals at all.
I've heard about
I've heard
some,
about
yeah,
Yeah.
yeah.
I mean, a lot of people are in that space now too, so within certain parameters, say, like sometimes I see on newer HOAs, will allow up to X percentage to be used as rentals, because they don't want the whole freaking neighborhood, right, with short-term occupants. You know? Our short-term rentals leases, that's another, I'll get to you in a little bit. Our short-term rentals leases, that's another question posed by this case. Yeah, so long as it has the characteristics of the lease, the right to use and occupy the property. Trial court had no basis from which to conclude that Jay Bryce, who was renting his townhomes, were not leases. Okay, all of those factors to consider whether or not he could continue this based on what the covenants say that we've gotten up. In interpreting covenants, courts do not extrapolate restrictions beyond those to which the owners agree, particularly here, where the covenant, I'm on 20, left side of 20, where the covenants expressly forbid it, because Wilcrest covenants do not require owners who choose to rent their townhomes to do so for a particular duration. Shame on the HOA for not doing that. The trial court erred in imposing a minimum lease term and by issuing a temporary injunction, right, keeping him from leasing. The property code permits property associations in that county to regulate property uses within a given subdivision unless the governing documents say the association cannot. So here, this is where it's held that the association's rules prohibiting short terms, STRs, conflict with Wilcrest deed restrictions because the restrictions otherwise provide that the association must not restrain an owner's right to lease a townhome. Restrictions found in the neighborhood. And that's why I was saying it's unique to what the restrictions might say. Because this one, they basically gave power to the homeowner, right? And then, like we're going to close with, you have to take into consideration what the city plans and commissions say. Actually, this is the one where I was talking about 75%. Yeah, should 75% of the town homeowners agree that deed restrictions permit the neighborhood to amend covenants to restrict leasing, and under the current version of the deed restrictions, the association may pursue relief from a tenant's nuisance or anyone. Top to 22. We're on the adverse possession, quiet title, title disputes, and partition section. Oh yeah, terminology you guys are used to. I didn't say it perfect today. Joint ventures. Many of you are part of joint ventures. Joint ventures gone south. What happened to Stally and Deloach? Stelly lived on and rented the land in question. This is Supreme Court. When it just says text, it doesn't say color or anything, it's the Supreme Court. Stelly lived on and rented the land in question since '99. In April of 2000, they decided to form a joint farming venture. They purchased farming equipment, etc., etc. Part of their joint venture said that Deloach will deed the property to Stelly. Same with all equipment purchased. What kind of agreement is that?
One-sided?
What's that? One-sided. What kind of agreement is that whenever you say, hey, if this happens, then I'll give you a deed at the end?
Contract for deed.
Yeah, executory contract, right? They probably just intended to form a joint venture, but they're in the executory contract realm now. Sucks for them. That's why they made the Supreme Court. Stelly fully repaid Deloche by 2005, so fairly quickly. Despite performance by Sally, Amy, Deloche didn't transfer ownership to Stelly. Legislators hate that. So do the judges. Deloche stopped paying Stelly for her work on the farm. They had a separate agreement for that. And announced that Stelly owned nothing and that he intended to sell the 600 acres. Stelly sued for breach, of course, and for the sale of the land. Trial court said that judgment holding that Stelly owned the real property and the equipment free and clear. Another overreaching use of discretion, maybe. I mean, I agree with Stelly in the beginning, but everything free and clear. Deloche that bad of a person? Court of Appeals reversed, held for Deloche, saying that Stelly had pleaded only a breach of contract claim. So I say, if you don't raise it, you waive it. That's on the attorney right there. I'm sure she had. Or he, rather. Stelly had pleaded only a breach of contract claim, not a trespass to try title. Why didn't you? Shame on those attorneys. The cause of action on the breach of contract claim accrued in 2005, and therefore limitations had run on the claim. We haven't even talked much statute of limitations today, but it's going to change depending on the circumstances. And right here, it actually changes depending on whether you are saying breach of contract or whether you're doing trespass to try title. Different limitations periods. Court of Appeals noted that a trespass to try title claim would have been timely, because it's not a shortened, 2 or 4 year statute of limitations. The Supreme Court in Broomley held that, or based on Broomley, the Supreme Court held that Stelly had adequately pleaded a trespass to try title claim and had acquired equitable title upon completing payments to Deloche. This back and forth happens all the time, guys. Trial court will say something, Court of Appeals says, nah. The Supreme Court says, well, an equitable title claim here. All right? These are the elements of trespass to try title, which I'm sure you're probably thinking about asking. Parties, names, and residences, easy. Legally sufficient description on premises. It's one of the main things that we always want to know is accurate. Legal description. Legal description. Any type of file. The plaintiff's claimed interest. Let's see the acreage that she was paying for and getting the deed. The plaintiff possesses the premises when he's entitled to possession. Probably needs both, but it's in the alternative, either or. That the defendant unlawfully entered and dispossessed the plaintiff of the premises and withholds possession. Definitely happening by Deloche. And a prayer for relief. The lawsuit would include that. Supreme Court said that Stelly was vested with an equitable title of property sufficient to enable him to maintain his action and trespass to try title. So, met all the elements. You can't just meet 4 or 5 of them. Met all of them. Not just equitable title. I'm sure part of that order said, Deloche, you signed that deed. At least a special warranty, in my estimation. Oh, this one's good too. So we're going to go to Maroney. Appellate District. We're back in Houston. Back in 1935, Dew conveyed a couple acres to a church. It conveyed surface rights, but it had conditions. Land had to be used for church purposes, and it couldn't be used, if it wasn't used for that, it couldn't be abandoned. Title would revert back to the grantor. Remember, first hour we were talking about conditions, right? And this case is going to determine whether or not it was subject to a condition subject or whether it was a determinable interest, which would then affect the reversionary interest, whether I automatically get title again or I get it only if this happens. That's the subject to condition subject. You automatically get it back if the judge deems that it's a determinable interest. Okay? Determinable, automatic. Subject to is right of reentry. So So the church claimed that, this is why the church wanted to bring suit. Donors and investors were denying financial assistance to the church because of the possibility that Moroni had a future non-possessory vested interest in the land. Moroni is one of Due's heirs. So stay there. So how'd they find out? How'd those banks or possible suitors find out that, hey, there might be a non-possessory future interest that affects title of this property? Search. There you go. Yeah. So what is my Schedule B going to have? That deed that imposed this limitation and restriction on the property. It's going to show you the recording of that instrument from back in 1935 that said, this land is not used for church purposes, or if it's abandoned, Dude's going to get the property. So why did this go all the way to the So one of the issues that the parties had too, which you're probably thinking about, okay, so the language of Dude's deed from 35, it said, you don't abandon it and you use it for church, cool. If not, it's mine. That's it. We're talking about heirs. So, Dude's going to die eventually, right? So what happens when Dude dies? Does that limitation die with him? That's where Moroni comes in. Moroni's there. Right? Moroni says, no. Hey, I'm right here. I still have a possible future interest, right? As one of the heirs. And that's why when the church asked for a declaratory judgment, Moroni counterclaim, she said, I'm a holder of a reversionary interest under the terms of the original deed from 1935. You guys, this is 2021. Yeah. Trial court said, Due granted a fee simple surface estate subject to a condition subsequent. So what's a reversionary interest there? Let me say that. It's a right of re-entry. It's not an automatic right. It's a trial court said. Not a fee simple determinable with the possibility reverter, and that any right of re-entry for breach was solely for the life of Due and terminated at his death. Trial court also held that if the foregoing is erroneous and the right of re-entry was not terminated by death, the right of re-entry expired upon, sound like a commercial, expired upon the adverse possession limitation statutes or the expiration of a reasonable length of time, and the trial court awarded $80,000 in attorney's fees to the church. What do you think happened at the appellate level? The historical distinction between two types of the reversionary interest that we're talking about is that a possibility reverter is set to transfer possession automatically. Okay? That's piece of determinable. Or, while a right of re-entry requires some action on behalf of the holder, action on behalf of the church. Parties agree that the deed uses language that has been associated with creating either a possibility reverter, with words as so long as and revert. When there's no doubt which type of interest was intended, the doubt must be resolved in favor of the right of re-entry, that is, as it is in a sense less onerous upon the grantee, in that under such a construction, the estate does not terminate automatically. So this 25, left side. Central issue is whether the deed, by referring to the reversion to the grantor rather than his heirs too, had the effect of limiting the term of the condition to Due's life. What do you think? Although Texas case law on this subject is sparse, that's why 2021 from the 1935 issue, a review of authority shows that generally heirs have not needed to be referenced in the deed to enforce the grantor's right of re-entry. It's different, right? But generally speaking, you don't have to say Due's heirs. And Moroni probably had standing here. The court held that the reversionary interest did not terminate at Due's death. No statute of limitations or equitable requirement for the exercise of the right of re-entry could arise unless the church breached the condition, obviously Moroni's contention. Accordingly, the Court of Appeal said, trial court, you erred by saying that it expired. Anything else I want to extract? Oh, and the attorney's fees was the first two. That's for the church, right? Anyway, that's the biggest takeaway there.
So there's no statute of limitation on reverter interest.
Well, it can't be perpetual, but I don't think that's it. No. There's no need to, which is ironic, there's no statutory precedent that says you must talk about heirs if they're going to benefit after the fact. There's no necessity to talk about the heirs or mention them in the deed if they're going to benefit. I can see that because they would conflict with the estate's code, right? If you as a title holder pass, in your will, don't you want your heirs to benefit? Even if the deed didn't say otherwise?
Guess you could say these are the do's and don'ts. What you should do, right? These are the do's and the don'ts.
Yeah, exactly.
So they stopped using it as a church. So
No, they didn't.
Oh.
But if you want to do a hypothetical, sure.
no, but isn't that why he trying to get interest on it?
No, the church wanted to get more debt on it,
The
right?
church
Yeah.
wanted to get debt, but that's why I said, what happened here? Oh, the suitors, the banks, right? They looked at the title commitment and said, whoa. Look, hey, send me that deed from 1935. What's going on here? Oh, there's a question as to whether Dew and his heirs still have a possible future interest. So if they lend $5 million to this church, and for some reason Maroney,
They
tries
sell
to
it to the
claim
liquor store.
abandonment. You're not running a church, you're running a business, right?
Well, you could say that about.
Sue something for anybody.
But the
Sue
crazy
anybody
thing
for anything.
is Moroni probably didn't even know she had interest in this until the church brought it up, and now
100%. I
Yeah.
agree with. I don't know that for a
Let
fact.
sleeping dogs lie.
But, wow, God, yeah. Oh, what? Yeah. Yes.
Could I ask a hypothetical on a
Sure.
similar situation? 2 acres deeded to church, no abandonment or doesn't go back to the grantor, not in the deed, and the church just goes away. But the members of the church own the 2 acres.
Okay.
There's 300 members that have, most of them have died.
Mm-hmm.
Is that just an adverse possession situation? Somebody wanted to take it over. There's no one there to be a grantor of a deed.
Could be. So, yeah, you answered the question that I would have asked. The 300 didn't create a board giving somebody authority or capacity to be a grantor?
No.
Then I don't see a way around not involving the 300 to eventually at least sign an instrument of authorizing Tim to sign on their behalf, like a power of attorney, right? Or if not, you have 300 grantors, it sounds like.
And their heirs if it passes away.
And their heirs if they pass away, you bet. You can't have any title in Texas. Does it leave a will? No? Oh, man, we have to go and file your heirs now? Yeah.
Or quiet title, whoever more in the grass.
That might be more efficient than tracking down
300
people.
So if
And the heirs.
someone has shown that they've taken possession of it for like 20 years,
Paid the taxes on it.
Then
pay taxes.
it would absolutely be more efficient and cheaper, in my estimation, to go ahead and suit the quiet title.
Yeah.
There are multiple adverse possession statutes, starting with as early as like 2, not really used much. There's a 5, that includes taxes. There's a 10, and there's 2 25s, right? They each have different factors. So, based on what you're telling me right now, then yeah, I think it'd be a lot more equitable to go and file suit to quiet title or get you an adverse possession claim.
Yeah.
Courts here don't. I think it's still true because the DA doesn't like them when adverse possession affidavits were being filed loosely. So I think the courts, with my suit to quiet title, would be more effective. But I would have an ancillary ask for an adverse possession claim too.
Well, on adverse possession, you still have to go to court, right?
Absolutely. You can't just file an affidavit. So
Yeah.
I was talking about people were filing these affidavits claiming that they own these abandoned properties right after all the foreclosures and changing locks because they filed an affidavit. DA cracked down quickly.
Because there's a lot of abandoned churches out there. So
I wonder how many are subject to
Yeah.
covenants like that, or subject to conditions of support.
Well, they still have to serve the 300 people, right? So that'll be an expensive suit, like $75 per person.
What
It'd be an
determines
expensive
who?
suit, but it'd be more efficient
Oh, yeah.
to go ahead because all you need is last known address. And what if they don't even answer? You default them. You're done. I'm down to 200 now, right? Not that easy, but potentially easier than getting a title company to go track down 300 grand tours. What else do we have? I just wanted to point out, if you guys want to read 26 later, that the judges kind of have fun. This is a dissenting judge, didn't agree with the appellate court's ruling in the way that he had fun with his dissenting opinion. 242 ways to actively make change for a dollar. We didn't like it. Kind of quirky, but let's see. Okay, yeah, we're talking about adverse possession, and this one deals with the 10-year, 27, Castillo v. Luna. To prevail under the 10-year statute, a person must prove by a preponderance of the evidence that possession of the disputed property by the person or by the person's predecessors was actual and visible, they have to be on the property, adverse and hostile to the claim of owner of record, not hostile like, hey, I hired my guns, and I'm going hostile on you. No, it's just a legal term to say that. Look, it's open. I'm here. I'm telling you, I'm claiming this property. Open and notorious, peaceable, exclusive means there's no break. You can't, hey, I was here for 4 years, and then, I left for a little bit, but now I'm coming back. Generally speaking, you can't tack on those years, right? And that's why the exclusivity requirement is on number 5. The last one is involve continuous cultivation, use, or enjoyment for 10 years. That's Property Code Section 16. Claim of right means claimant entered, possessed the property as his own. Luna family entered in the 60s, and they were tenants. They didn't claim ownership, but a disputed strip, that's at issue here. Sylvia and Garcia claim only that the Luna family initially rented Lot 11, and that they believe the disputed strip was part of the property. Earliest date that the Luna family would have claimed ownership was 73, when Manuel and Alice Luna bought 11. So adverse possession need not continue in the same person. Rather, limitations may be proved by tacking. Tacking, I mentioned earlier, but tacking has to be continuous, right? You tack if it's continuous. It can't be a break in the timeline. By tacking, that is by accumulating the periods of possession each holder and successor, that's where this is going, between whom there is privity of estate. If the successors, right, you pass, but your heirs continue that claim that meets all 6 elements, then that's how you can tack. Going down to 28. Okay, so let's finish with STRs. We're at 40. That's the only case that I have on zoning and land use planning too. It's the Arlington, I mentioned. Yeah. So Draper was one of many plaintiffs. I don't know exactly how many, but this one obviously went to the Court of Appeals here in Fort Worth last year. So there's been an uptick in short-term rentals, obviously in the Arlington area for reasons that we stated already, right? So the city, because of the influx, said these are all the problems we have: noise disturbances, hand wild parties, excessive street parking, as well as trash overflowing into streets and tenants engaging in fistfights. That's pretty narrow there. But those are the Cowboy game, the Cowboy team, into those games. Engaging in fistfights and urinating in front yards. Right? It's a Cowboy game too, right? Who does that?
Do that in the stadium.
Yeah, right?
That's
a Wednesday night in my house.
According to Arlington, I'm so shocked that they quoted an Arlington resident here in the opinion, but they did. STRs are a nightmare for neighbors. Like, let's try Karen Garcia. Sorry for James Karen. That was a joke. My last name is Garcia. In response to increasing use of STRs and their attendant issues, the city engaged in extensive period of public comment. I'm sure you've been to city meetings, invited a lot of public comment, hired people to come in just to see how they could address the STR issue. City Council then enacted the zoning ordinance and the STR ordinance. It created an STR zone that I was talking about, right? You don't just want to not allow people to do that. Let's stay there. Are we hosting the World Cup? We were watching it last meeting. Are we hosting the World Cup later this decade? Oh, we absolutely are. Do you think that zone's going to grow? Oh, yeah, it is. I bet you anything. You think the city's not going to get their taxable income from all your STRs? Right? Bet it starts happening. This is my guess. Anybody in the Frisco space? Big golf man, obviously. PGA is coming in, right? Once those major tournaments hit our area too, you would think all those nice homes in Plano, Frisco, City are might be subject to a zone like this one. The STR ordinance in turn prescribes the permitting process and imposes regulations on STR owners and tenants. The homeowners in this suit own properties in the city, obviously not expanding. Neither of their homes are in the STR zone, why they brought suit against the city of Arlington. Homeowners sued the city and its mayor seeking the following declarations. The ordinance violates freedom of assembly rights under the Texas Constitution. I don't know where these things are going. Yeah, thank you for picking up on that. Violate the homeowner's substantive due course of law rights under the Texas Constitution. Seriously, that's where we're going with this. The ordinance violates the tenant's freedom of movement rights under the Texas Constitution's substantive due course of law. And the ordinance violates the equal protection rights under the Constitution. Obviously, the homeowner sought an injunction to keep the city from doing this. The trial court denied the injunction. The elements to get an injunction, go over them later, right there. Okay. I say go over them because I get so many calls, especially when it comes foreclosure time. Hey, can you get a TRO for me? Yeah, let me write one up. No. Right? To get an injunction, you have to have a proper cause of action. That's what I tell people that call me. What's your cause of action? You can't just go magically stop the foreclosure because you want the house that the debtor can't pay for anymore. What's my cause of action? Right? I have to have something besides, hey, don't foreclose, I'm going to buy this. Title's not ready to close yet. Proper cause of action, a probable right to the relief sought, and a probable imminent and irreparable injury in the interim. That's to the person, right, that you're seeking to enjoin. Point is, don't call the attorney. Hey, can you get me a TRO? Don't wait till the last minute for foreclosures, too. Top on the right side. Ordinances are presumed to be constitutional. To overcome that presumption, you must prove either that the statute's purpose could not be rationally related to a legitimate government interest. That's the first one. Is this a legitimate government interest? Well, if I had to withstand parties and typical Tuesday nights being in Ryan's yard, I'd want maybe the city to step in and do something about it. Right? Is this a legitimate government interest? Or, when considered as a whole, the statute's actual real-world effect as applied to the challenging party could not be rationally related to the government interest. So to pass constitutional muster, an ordinance must be designed to accomplish an objective within the government's police power and rationally related to the ordinance's purpose. City's arguments. No, the next page. Safeguarding the life, health, and safety, welfare of our citizens, right? Number 2, minimizing the adverse impacts resulting from increased rental uses. Homeowners, on the other hand. Okay, even if that's true, the city presented evidence that can disrupt residential neighborhoods that restrict STRs to the STR zone. And the skinny is, even though they had standing, because they, like you, own property everywhere, they couldn't prove that the zone didn't provide or back a legitimate government interest. Okay, they said make it bigger. Like I said earlier, in my opinion, I think it will be bigger in the future, especially with the big events coming. Probably have a Super Bowl at some time, I would think. It's been a while. But for now, it serves a legitimate government interest, and the zone is going to stay as is. Yes?
Wouldn't they have to give some type of argument as to why they set the zone the way they did?
Absolutely. And,
Yeah.
Skipped over a lot of facts, but the city hired professionals to make a determination, invited folks, I think, 20 times to come and give their take on whether you agree with it or not, right? Yeah. Some folks would say, well, I want to rent my house. Others would say, no, I live right by you. I don't want rentals over here. So there's a lot of research and background that went into it, yeah. What else?
So I don't do short-term rentals. Is there a lease agreement that goes with those? Anybody doing short-term?
Yeah, the sites have lease agreements, but
So in Texas, do you have to use Texas property code with those short-term leases? What if they don't move out? How do you?
it happens. You then have to go with an eviction.
So, if you want to bulletproof your eviction case, what would I require of you? On top of what the site has, you better sign something.
That's what I was wondering.
Yeah, because that's part of my bulletproof evidence at the Justice of the Peace Corps. I want something that's unique to me and you that's renting from me, not my rental site that runs it for me. I want something that's unique to you and I.
Does the short-term rental business, website, do they have late fees after starting day one and all that?
Hey, it's happening already in my backyard. Rodeo season, baby. My buddy who owns the building that I'm in over on the west side downtown has the containers if you're in that area. People stay there for months, at least for the rodeo.
I'm doing a couple of loans right now for Airbnb. And Fannie Mae's guideline is to count the income to offset the payment if you needed to qualify. And if you have quite a few properties, you might need to qualify.
Yeah.
There has to be a lease, but it doesn't say how long the lease has to be. And my borrower would not ask his management company. He felt like that was either not available or not appropriate in order to qualify. So he's just filing his issues taxes to show more income so he can qualify.
How is it structured?
But he had an opportunity to provide a lease, a direct lease, and would not because he felt like it could be.
You thought that the POA might raise some flags whenever that's a question, right?
You say that's for a mortgage loan? Well, the underwriter sets their requirements. If they don't comply, the underwriter can say denied, right?
Well, we have to go by Fannie rules, yeah. But they talked to Fannie, and Fannie said a lease will suffice.
Yeah.
But he said they don't sign leases. My management company doesn't have them sign leases. They go on site, they pay the fee, there is no lease signed. And so, of course, I don't want to be a part of something that's not, you know.
Yeah.
He may not
Correct.
know that there's a lease signed. Because like Airbnb doesn't show the landlord a signed lease, but they do have the tenants basically
Surely in
sign.
fine print, it's the
It's a
equivalent.
generic one though that I don't even know if it's state specific, but both VRBO allows you to upload your own. Airbnb, I don't know if you can, but they have leases that are signed. But like the reason I asked how he's structured, so like for me, I own the property in an LLC, but then I have another LLC that is actually the company that manages it. And that management company leases from my other LLC on an annual basis so that I have the ability to do depreciation. So you can't depreciate if it's 28 days or less on your average tenant. And so that's why I wasn't sure like if he structured that same way, which is how a lot of short-term rental people do structure, that he would then be able to provide that long-term lease. It's written to him from one company that he owns to another company that he owns. But that might be one
Oh, that's a good idea.
way. But he should be structured that way if he isn't, because there's a lot of tax. I'm not a tax professional.
Yeah.
Don't come to me. I'm not your CPA. But he should probably, I would advise him to talk to someone because he should be structured similarly if he isn't. Otherwise, he's leaving a lot of money in the government's pockets.
And we talked about it in the earlier section, page 20. There was a Supreme Court decision that was referenced, not that we went over it. It said a short-term rental is a lease so long as it maintains the characteristics of the lease. So, that person other than that in court then, at least there's top of page 20. There's good case law to suggest that an STR is a lease so long as it meets the characteristics of a traditional valid lease. Hey.
This has nothing to do with short-term leases. It's just a direct question to you.
Yeah.
What is it with the title companies that these days, outside of your title company,